Welcome to the Tritel Patents Workshop, what you need to know about IP. Hey everybody, new tie today. What do you think? Please leave your comments in the box below about my tie, if you're opinionated about it. Today is the third episode in our series, and we're going to be taking a step back. Until now, we've been speaking about patents, and really a certain type of patent, which I'll name a little bit later. But there's really more to IP than patents. So let's talk about the different types of IP, intellectual property, that there are. What exactly is intellectual property? What's the definition of it? I think a good definition is something which is a creation of the mind. It could be a new device, it could be a play, a song, an advertising slogan, a novel, a painting. All these things are things which are property which is non-physical. And that's the important point here. It's an intellectual property. Now you may say, well, hold on a minute. A device is physical. Why is it intellectual property? And the answer is, let's say you get a device, you design a device and you get a patent on that device. The patent is not preventing somebody from breaking into your house and stealing your copy of the device. The patent is stopping somebody from copying the design of the device. An aspect of the newness, what's new about your device. Whatever the new aspect of your device is, that's an intellectual property as opposed to physical property. So all these things fall into the general definition of IP. Now, as I mentioned, there are different types of things that can be protected from IP. Devices for mass production, songs, plays, advertising slogans. And just like there are different types of things that can be protected, there are different ways of protecting them. The three major types of IP that I'm going to speak about today are patents, copyrights, and trademarks. There are two types of patents, which we'll speak about a little bit later. But patents in general protect mass-produced devices, machines, or processes. What about copyrights? A copyright protects an artistic work, which could be a variety of artistic things, such as books, movies, paintings, sculptures, etc. Anything that's artistic is protected by copyright. The last thing is a trademark. The trademark protects the reputation of a company and the goods or services that a company provides. So for example, an advertising slogan or a name of a company can be covered by a trademark. Now, Nike has a trademark on the shoes that they sell, for example. If I sell my own shoes, which are not Nike shoes, and I sell them under the Nike symbol, I am compromising the reputation of Nike, and I am infringing the trademark of the Nike company. If I take a book that someone else wrote and sell it to make profit for myself, I'm infringing the copyright of the person that wrote the book. If I copy someone else's device that's covered with a patent and I sell it for my own profit, then I'm infringing the patent that covers that device. We mentioned that there are two major types of patents. Those are utility patents and design patents. They differ in the following way. Utility patents cover the functional features of a device or machine or process. What makes this device, machine, process better than the previous ones? On the other hand, a design patent, or sometimes also known as an industrial design, protects ornamental or aesthetic features of a product. Let's give some examples of functional features that can be covered by a utility patent. A laser that's more accurate. An improved type of controlled release coating on a pill. A thermal battery with improved efficiency, or an improved chemical reduction method for removing pollutants from a mixture. What about aspects that can be covered by a design patent? This can be, for example, a new design for an earring.
That's totally radical.
A shape of a bottle, for example, the shape of the Coca-Cola bottle, classic example of that. A car chassis with a pleasing design, Corvette, for example.
Now, what if you have an improved earring clasp
that works better, that holds the earring better than the previous ones. That would not be covered by a design patent, because if you're covering the functional aspect of it, that it holds the earring better, that's going to be covered by a utility patent and not by a design patent. So you could, in the case of the earrings that we mentioned, and in many, many other cases, have the same product covered by both the design and the utility patent. That happens all the time. They're both protecting different aspects of the same device. There are other types of IP that I'm just going to touch on briefly today. I won't get too much into them. And they're types of IP which are applicable in certain countries specifically and or certain circumstances. One is utility models in certain countries. This is hard to describe exactly, but it's a simplified type of a patent that concerns limited rights. You can find more about that by consulting with us. There are a couple different ways of covering new plant varieties. There's something called a plant patent in the US. There's another thing called another mechanism called the plant variety protection. And the last thing I'll mention are trade secrets. Trade secrets are a way of protecting things that you don't want to publish, and therefore you don't want to patent. And you protect it by obligating all of your employees and anyone who's exposed to this to secrecy and keeping it as a secret. A classic example of a trade secret is the recipe of Coca-Cola. Now again, as usual, if you want to know if what I said was clear, there's going to be a quiz. But you guys are really lucky today. In addition to my new tie, you're going to have not one, not two, and not three, but 4 quiz questions. Are you ready? For each question, pause the video until you know the answer. Question number 1. How's the purple color of Cadbury chocolate protected? A patent, a copyright, or a trademark? And the answer is it's covered by a trademark. It's a way of protecting the reputation of Cadbury and preventing you from confusing Cadbury chocolates with other companies. Question number 2. How is the text of a newspaper article protected? Patent, copyright, or a trademark? The answer is copyright, because it is the text of the article is a type of a composition that's considered to be like an artistic work. Okay, now we have a multiple choice question where more than one answer can be correct. Are you ready? Which of the following can be protected with a design patent? The shape of a bracelet, a powerful hybrid car battery, diagnostic test, a sleek new fabric, an attractive company logo. Let's go through the answers one by one. 1 is the shape of a bracelet. This can absolutely be protected with a design patent. Powerful hybrid car battery? No. That's not appropriate for a design patent, because there you want to protect the functional aspect of the battery. Diagnostic test usually is also not going to be protected by a design patent, because you're not protecting the way the test looks, you're just protecting the fact that it works better. A sleek suit fabric? Absolutely yes. Perfectly appropriate for a design patent. The last one is a little bit of a trick question, an attractive company logo. So you might think this because it's attractive, it would be covered by a design patent, but no, because it's a company logo, it is designed to associate goods or services with the reputation of the company, and therefore it's going to be protected by a trademark and not a patent. The last question, which of the following can be protected with a utility patent? Number 1, a durable bracelet clasp. 2, attractive packaging or a diagnostic test. 3, a lightweight suit fabric. And 4 is a mosquito trap. Okay, answer number 1, a durable bracelet clasp. The answer is yes, it can be protected from a utility patent, even though it's part of a piece of jewelry, which is usually covered by a design patent, but you're protecting the functional aspect of it, the fact that it's durable. It's not going to break as easily as other bracelet clasps, and therefore a utility patent is appropriate. Number 2, attractive packaging for a diagnostic test. This is not the fact that you're covering the attractiveness of the packaging means it's not appropriate for a utility patent. It is appropriate for a design patent. It's part of a test, which does have utility, but that's not the aspect you're protecting with this patent, and therefore it is not appropriate for a utility patent. Number 3, a lightweight suit fabric. Absolutely. This is a classic example of something that is going to be covered by a utility patent. Number 4, a mosquito trap. Again, example of something which, yes, would be covered by a utility patent. Thanks for attending. The last thing that I like to say, which is very important, is that nothing in any of these episodes should be taken as legal advice. Please speak to a competent patent professional to get proper legal advice. Have a good day.